Cases captioned State of Ohio versus Lieutenant Henderson. Cases 25 CR 001119 and 25 CR 001086. We were last here on August 19th, at which time the defendant entered written and oral pleas of guilty to failure to comply with order or signal of a police officer in case number 1119, that being a felony of the 4th degree in violation of 2921.331B, and in case number 1086, a felony of the 3rd degree in violation of the same section. The case was referred for a pre-sentence report and investigation and drug and alcohol evaluation. Those have been completed. We are here today for purposes of sentencing. Defendant is present with her counsel, Mr. William Watson.
Thank you. Mr. Watson, any reason why we shouldn't go forward with sentencing?
No, Your Honor.
Anything you want to say on behalf of the client?
Thank you, Your Honor. May it please the court. Ms. Henderson is a troubled woman with a long history. I know we had some discussions in chambers off the record. She's got a long criminal history, which includes a stint in federal prison, and most recently, she had picked up a case out of Cuyotta County. I believe, while that case was pending, these two cases she committed. On the Cuyotta County case, they had sentenced her to CBCF, which is their version of NeoCap, and then Ms. Henderson was transported here to this county to face these charges. From the moment I met her, Ms. Henderson has expressed her sincere remorse for what she's chosen to do. And the root cause, Your Honor, of her issues are her addiction to drugs, specifically to ecstasy. She had a very strong addiction. She was taking multiple pills a day. I believe she's admitted to probation at one point. I think taking 18 pills at one point in time for one of these cases. While she's been in county here, she's obviously detoxed. She's got a clear mind. She has told me from the very beginning that she wants to straighten her life around. With the Cuyahoga County sentence, and I know that has nothing to do with this court, but when they were going to send her to the CBCF, Ms. Henderson was actually excited. She was thrilled that she was going to go to a place where she can focus on herself and hopefully get the help that she needed. While she's been sitting here, she has told me from the beginning that she would welcome either that opportunity or this court's version of that, which is NeoCap. She's also been assessed by Lake Geauga. I believe that their full assessment was quite long with what they recommended. Ms. Henderson has told me she would welcome all of that with open arms. And on top of that, she wants to begin mental health counseling. So on top of her drug addiction, she feels she has some mental health issues that she'd like to address. Your Honor, here in court today is her family, her son, her mother, here in support of her. I know that there's zero excuse for her actions, zero excuse for being high, if you will, and committing thefts, and then running from the police at very high rates of speed, I think, in both instances. And Ms. Henderson is not shying away from her responsibility, Your Honor. She said from the beginning, yes, that was me, yes, I did it. But she's also told me, and she's here to tell this court today, that yes, I want help, and I want to change who I am, and I want to be a different person. I know, Your Honor, based upon her record, that there would be basically zero reason for this court, or really any court, to consider what I'm about to ask for, but I think Ms. Henderson would do well in a very structured environment, i.e. CBCF or NeoCap, and then after that, a very lengthy period of drug treatment and mental health treatment. We're not asking for a slap on the wrist here. Ms. Henderson knows that what she did is very serious, and if this court were to consider what I'm asking for, we're open for whatever length of period of time probation the court would deem appropriate for this. But Ms. Henderson wants to change who she is. You're going to hear from her in just a second. I know her actions don't warrant it, Your Honor, but I think her attitude does, and I'm going to respectfully ask the court to take that into consideration. Thank you, Your Honor.
Thank you. Ms. Henderson, you have the right to address the court before your sentence. You can say anything you want. Is there anything you want to say at this time?
Yes, Your Honor. I had wrote you a letter, but I left it in my cell, but I rewrote it. So, dear Honorable Judge Culotta, I want to apologize for appearing in your court today. I wanted to take full responsibility of my actions today. I'm coming before you to ask you for help. I've never thought that I needed help for anybody, or always thought I could just do everything myself. My drug addiction has gotten way out of control to the point where a lot of bad things have happened. I'm asking you for help because I wanted to be a better mother, a better sister to my family. They told me I've needed help plenty of times, but I've always ignored it. I want to do better. I want to be a better person for my family. And yet again, this is no excuse for my actions or anything. I take full responsibility for my actions, and I actually am embarrassed to be in front of you today. But if you can't help me, I was wanting to ask you, can you point me in the direction where I can get help? Thank you.
Thank you. Mr. Watson, anything else on behalf of the defendant?
No, Your Honor.
Ms. Linden for the State of Ohio.
Thank you, Your Honor. Your Honor, as indicated in chambers, the state is recommending a prison term. There's just not a way to turn a blind eye to the history that she has. And in terms of looking at these offenses, in case 1119, this is a pursuit of about 9 miles on State Route 44 and 2, going 115 to 120 miles per hour. And then in looking at...
1119?
Yes. And then 1086, in that particular case, she was going at speeds of 100 miles per hour, going on the shoulder, passing, cutting off a semi, and looking at the fact that she actually briefly almost lost control of her vehicle as well. So when I look at those two things, and then I understand that she's saying that she wants to be a better mother, better sister, better daughter, but where was that thought when these things were being committed and there were people out on the roadway and she was high while she was doing this? And then not to mention the fact that they had to set up those stop spikes for her, and not to mention the fact that while this is all going on, she had several warrants for her arrest, which is, I'm sure, part of the reason that she fled. But even in terms of talking about what was going on in the Coles while this is happening, she downplays that as well. She was with this person, like I said, Bobby Rayshawn Slaughter Jr., and my understanding is that she's with him on a number of these other occasions. So where is her taking responsibility for her child and taking some responsibility and actually getting herself into treatment while she's committing all these? I mean, it took, just to go through her history, it's atrocious. The fact that she has a federal prison term, that she has a history back to at least 2009, not to mention a multitude of traffic offenses, and she has all these warrants out for her even now. I'm actually, I guess I shouldn't be shocked that Cuyahoga County decided to do a CVCF, but I am, based on the history that she has. And the fact that she has a brother who's a Rocky River police officer, to me that kind of smacks of really not taking responsibility, when she knows full well here that there were police officers that were chasing her, trying to stop her, and that while she was trying to leave the Kohl's parking lot, she almost backed into a police officer as well. So in terms of looking at the state, that the state would recommend a prison term of 4 years, 36 months on case number 1086 and 12 on case number 1119, with the class 2 requisite driver's license suspension, the mandatory post-release control. She does have 76 days of credit for time served. Thank you.
This court reviewed the pre-sentence report and investigation, drug and alcohol evaluation, consider the facts and circumstances of the offenses involved, the nature of the offenses involved, and consider what's been said here today. All this is considered by the court in light of the purposes and principles of felony sentencing set forth in 29-29-11. Now, as for the factors in 29-29-12, factors indicating the conduct is more or less serious, the court first notes that, if you're going to believe the defendant, she was extremely high at the time she committed these offenses. So she's operating this motor vehicle on the public roadways with all these other vehicles around, extremely high. That makes it more serious. The other factors the court considers is her manner of driving. She's traveling over 100 miles an hour in the 1086 case. I'm just going to read this here. Traveling at 100 miles an hour between lanes 3 and 4 as we took the Interstate 90 westbound. There were multiple vehicles also traveling the westbound lane. Therefore, she traveled on the left-hand shoulder to pass these vehicles. The vehicle continued in lane 1 before it decided to move all the way across the lane to lane 4. It then went all the way back to lane 1 when it exited. And there, the traffic is, she cut off a semi-truck in lane 2 to exit at 185th. So in committing these offenses, she put multiple people at substantial risk of serious physical harm, committing multiple moving violations. The manner of her driving makes it more serious than the normal fleeing and eluding charge we deal with. Nothing makes it less serious for either case. As for recidivism factors, the court first finds the defendant has an extensive criminal history, goes back 16 years to 2009, which is right about when she became an adult. I think she was 19 at the time. And it just continued on. She served a federal prison term before in the past. She was on bond to multiple cases at the time she committed the offenses in both of these cases. She had multiple warrants out for her at the time she committed both of these cases. She has 2 pending fleeing and eluding charges out for her right now. So this is her MO. She goes into places, she steals things, and then she flees from police when she's trying to get caught. And the problem is, if you were here for just possession cases, you're blaming your drug problems for this, fine. You're only possibly harming yourself in those situations. Here, you're putting the whole community at risk in the manner of your driving. And you've done it over and over and over and over. Same MO, steal and flee from police and put people at risk. Further, I don't find there's genuine remorse because you don't accept responsibility. You deny even committing the offense. When you met with the probation department, you say that you didn't even know the police were there for you. You weren't trying to flee from them. You didn't even know that they were behind you for you. You saw the flashing lights and you sped up, but you didn't know what was going on. Well, then why are you driving 100 miles an hour on the freeway? Why are you going from lane 4 to lane 1 to lane 4 and exiting and driving the manner you are if you didn't think they were after you? That's a bunch of crap. But that's your story. So there's no genuine remorse. And then there's multiple warrants out. I mean, you're committing these offenses all over Northeast Ohio. There's multiple offenses and warrants for you for doing the same stuff all over. Nothing makes recidivism as less likely. Under 29-29-13B1 for case 1119, previously served a prison term or on bond at the time, that overrides any presumption in that case for community control. Prison is certainly consistent with the purposes and principles of sentencing. And based on your history, there's no way this court can find you're amenable to community control sanctions. I've already reviewed, and prosecutors set forth your criminal history prior to this. There's also multiple violations on your history, which is another factor indicating recidivism is more likely. But 2, your conduct that you engaged in isn't deserving of probation and demands consequences and punishment. Therefore, it'll be the sentence of this court in case 25 CR 1119, the fleeing charge, it's a felony of the 4th degree, that the defendant serve a term in prison of 12 months. She has credit for 76 days she served. I need to advise you in this particular case, upon your release from prison, you could be put on post-release control for up to 2 years, and if you violate any of the conditions, the parole authority can return you to prison as punishment for violating the rules for another 6 months, the maximum being 50% of the term I just imposed. Any additional prison term imposed for violating post-release controls being imposed as part of the sentence at this time. Court's going to suspend the defendant's driver's license for a period of 10 years. Case 25 CR 1086. The sentence of the court, defendant serve a term in prison of 30 months. By statute, it must be served consecutive to the prison term imposed in 1119. And since it's consecutive, there's no credit on this case because she got all the credit for the time she's been in our jail in the other case. In this case, the court finds that the defendant's conduct constitutes an offense of violence. Therefore, she acted willingly. She created a substantial risk of serious physical harm to others. Therefore, post-release control is mandatory in this case for a minimum of 1 year up to a maximum of 3 years. When you're on post-release control, if you're violating the conditions, the parole authority can return you back to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of the prison term imposed. Any additional prison term imposed for violating post-release controls being imposed as part of the sentence at this time. And suspend the defendant's driver's license for 10 years, and it will be a concurrent suspension. Defendant's ordered to pay all costs incurred in the actions. I think that covers everything. Is there anything else for the record, Ms. Linden?
No, Your Honor, thank you.
Mr. Watson?
Nothing further.